Hello, this is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Now, I'm also going to start off with handing out those 2 free consultations. To start, go ahead and call this number. It's going across the screen on YouTube, Instagram, on TikTok. It's at the top of the page, but you can listen out for that number. Is 561-405-4889. And you're going to say one love or one people. So one people. Go ahead, give them the code one people. And when you do that, if you are the first 2 callers and you speak to either Jalen or Eleanor and you're the first 2 callers, they will confirm that, then you will get 2 free consultation. We're handing out 2 free consultations. Go ahead and call the number and give them that. So the number is 561-405-4889. The code is one people. Just go ahead, tell them one people is the code for the free consult, and you will be able to get a free consultation as long as you're the first 2 callers. So go ahead and do that now. Because the staff, they're waiting and ready to answer your call and give you that consultation for free. Now, if you're not talking to Jalen, you're not talking to Eleanor, that means that you likely didn't get it. But you keep in mind that you can still go ahead and schedule if you need that appointment. And also make sure that you keep in mind that we're also giving out discounts. Throughout next week, we're giving out discounts to allow you to get the consultation at a discounted rate. Yeah, so keep trying. Now we have we have 6 more. So after today, we have 6 more free consultations that we're handing out. So don't give up yet. Stay tuned, stay engaged, and you'll have another opportunity. All right. So now I wanted to touch on a topic, and that is to the red flags in a VAWA application. When I say red flags, I mean when a VAWA application gets to the immigration and they're reviewing that application, what kind of red flags do they look out for that could possibly lead your case to complications or a straight up denial? So let's start with what is VAWA. So VAWA is the application that enables individuals, immigrants, to apply for their status here, their green card here, based on mistreatment, either verbal, mental, emotional, financial, and physical. It doesn't have to be all of them at once. Could be one of those or multiple of those, but it does not require physical mistreatment. Could be extreme cruelty as well. An example of extreme cruelty is where they're using your immigration status against you. So they're saying, if you don't do this for me, or if you don't do this, or if you don't do what I say, I'm going to get you deported. Now, that's an example of extreme cruelty, and it does qualify the immigrant to apply for their own green card. Now, once we determine that a client qualifies, so we, in the consultation, that's exactly what I do. I talk to clients, I get details about what happened to them, and then I make a determination based on my experience, based on my knowledge of the law, whether we can move forward with the VAWA petition and green card process. Now, in this case, what we do when we are working on the case, we make sure that we also create a good, thorough application to avoid any issues at the immigration side where they issue a request for evidence, or they start to nitpick at different aspects of the application. Now, everything in the application has to be true, right? So this is not a case where we are submitting any kind of false information, but what we have to make sure we do is we work with our client to make sure we are putting accurate, thorough, detailed information. And the reason we have to present such detail in the application is because that's the first red flag. And that's the first red flag to the officer is if you are submitting an application and you put for address history unknown, or you leave it blank, that's the first red flag. Or your employment history unknown, or you skip years, or you have gaps between the years that you worked. Um, that is a red flag. Um, so if it is a skeletal, I call these skeletal applications where and this tends to be the types of applications that people do when they're not using a lawyer, or they use someone who's not a lawyer. They tend to treat the information because they don't know the importance of this information. They don't know the legal implications behind each and every piece of information that the immigration officers want. And so they think, I don't remember my address, so I'm just going to leave it blank. In that case, what ends up happening is the officer zones into that missing information, and because it's kind of like it's not jiving, right? If you have a ton of gaps in what you're saying, that's going to raise red flags for anybody. If you're talking to someone, they're telling you a story, but they have gaps in it, it starts to look as if it's not making sense or it's not adding up. The same goes for the immigration service, is that when they spots these kinds of issues, they then question the credibility of our client, and we don't want that. So this process cannot be rushed, and it is not a process that you can fill out. This is not just about filling out paperwork. That's a part of the process, but there's a legal process here that you need to understand as well. And so it cannot be rushed. Everything has to be thorough, well put together, well done, and detailed. So that's the first thing. Don't submit a skeletal application. Don't just fill out the information that you have and not bother to look up additional information. So if, for example, you have to provide your address history in the last 5 years, but you don't know it offhand, don't treat it as if you're just going to shrug it off and file your application without the address history. You have to start doing some digging. Look back in your records to see where were you at this time. What did your lease agreement say? What did your bill say at certain times? If you keep your documents or if you're getting emails, you will have an address, and you could probably determine your address history based on just going back into your records and looking. But in this case, it's going to take some effort. We don't just accept, I don't remember, and put unknown on there, because that's just not going to be acceptable for an application like this. Another reason why it's so important to provide the address history, employment history, is because it helps the officer to piece together your background and what happened to you. So, say this VAWA petition is based on the mistreatment by a U.S. citizen or legal permanent resident spouse. A part of this is that you have to you have to show that at some point in your relationship, you lived with your spouse. And so the address history plays a huge part in telling the officer where you lived at what point and whether you lived with that spouse. So this is where it is not acceptable to simply state that you don't remember, because then the officer can look at that missing information and conclude that you do not meet the requirement that you lived with your spouse. So as you can see, there behind each question, there's a legal requirement. There's something that they're looking for to determine whether you qualify. And so the address history helps the officer to put your history with that spouse together and to be able to confirm that you lived with the spouse. So that's another thing. Now, now let's talk about the declaration and evidence. Evidence. The standard here for evidence is any credible evidence. So that means any believable evidence. It has to be presented to the officer in a way that when they look at the details, they understand that this is credible enough that it really happened to you. If you put together a paragraph of a declaration that says, I married my spouse on 10th of June 1999. My spouse abused me. I left my spouse and now I need the green card. If you put something together as vague as that, then that's straight up denial. Because in some cases, the declaration is the only piece of evidence that individuals can present. And what that means is that you have to make sure you put your all into the declaration. You have to put the proper details. And once again, because it sometimes is the only piece of evidence that will get you an approval, you have to make sure that you show in that declaration that you meet each and every one of the requirements for VAWA. So we not only in these declarations, when we review the declarations, we ensure that there's proper detail in there. How did you meet your spouse? When did you start seeing the red flags? What was the worst incident that you experienced? What was the incident that made you leave the relationship if you left the relationship? Uh, do you have good moral character? Why? When did you move in with this spouse? Because remember, there's the residency requirement. So when did you move in with the spouse? When did you get separated? All of that is going to be essential in telling the officer exactly why you qualify for VAWA. So if that declaration is not detailed enough, it's going to get you denial, straight up denial, and there's going to be a lack of credibility in your application. So that's red flag number 2. Now, another thing is you do have to show that you had a good faith marriage. Now, in this case, when it comes on to VAWA, and somebody says, "Here, what is VAWA?" I did explain it earlier, but it's where you can apply for your own green card if you're being mistreated by a U.S. citizen or legal permanent resident spouse, parent, or child. This process is confidential and it belongs to you. You don't involve anybody else. So let's go back to evidence here. So evidence of good faith when we're dealing with marriage. In any other case, when you're dealing with a parent-child relationship, you have to show that you have a valid parent-child relationship. So, for example, say you are the adopted parent of a child, but sometimes for example, and I think in any country, but in Jamaica, sometimes you have where somebody takes another child under their wing, raised them, but they never formally adopted that child. For immigration purposes, that would not qualify here as a parent-child relationship. It has to be a legal adoption. If you legally adopted the child, then in that case it qualifies here. But otherwise, if you just informally adopted a child, you wouldn't qualify here. You may qualify for other relief if you're being mistreated, but not VAWA here. So the relationship has to be an official, formal, legally accepted relationship. So in the case of marriage, though, you do have to show that you entered the marriage in good faith as an immigrant. And sometimes the evidence or a lack of evidence there can lead to a denial because it's a red flag for the officer. So if you say, for example, you submit your declaration but you don't present any kind of evidence to show that you had a good faith marriage, then that declaration alone may not save you. Now, with the save you from a denial. Now, with the this type of application, um, the evidence it depends. The kind of evidence of good faith marriage really depends on what kind of marriage you have. So this is where I'm going to say we are open-minded about the evidence that our clients have, and it's slightly different from a marriage-based process where your spouse is petitioning for you and your spouse is involved in the process. Because in the VAWA case, as the immigrant was victimized, the immigrant was subjected to mistreatment. That means that the immigrant spouse or parent or child, they were at a disadvantage. They did not have the power in the relationship, which sometimes means that they don't have a paper trail of the marriage. They may not be able to show a lease because maybe the spouse didn't allow them to be on the lease. Maybe they didn't have a joint bank account because the spouse didn't allow them to have a bank account or to be on the bank account with them. They may not be able to show even pictures because maybe that spouse didn't like pictures. Um, so, in this case, we look at it on a case by case basis. And so do the officers at the USCIS. They evaluate everything on a case by case basis. And they will take into consideration where you may have been limited in evidence. But in cases where there's no paper trail, and when I say paper trail, of the traditional evidence, so joint bank account, joint taxes, joint lease, these types of strong types of evidence, then we look to alternative evidence. So it could be text messages, it could be letters from friends and family who knew about the relationship, or it could be anything else. Because if you're married, you're in a marriage or you're in a relationship, but we're mostly focusing on good faith here, there's going to be something, as small as it is. We consider all options here and all alternatives to show the good faith marriage. Now, if you are applying with your spouse, just to explain the difference here, you're applying with your spouse, it's different. They're going to have a high expectation that you're going to present solid evidence because you're married. Your spouse is cooperating with you. They're not, hopefully they're not mistreating you. In some cases, there is mistreatment, but it doesn't come out till later. But your spouse, for the most part, is going to be, they're supposed to be involved. And so they're going to help you to present the evidence, like joint bank account, joint benefits, joint lease, so you're going to have that kind of evidence. But for in cases where the immigrant spouse is being mistreated, sometimes that's very difficult to get because there was an imbalance in the power dynamic between the two spouses to begin with. And so that spouse tried their very best to exclude the immigrant spouse from being able to empower themselves. So while the red flag here, though, is you don't present anything at all, you just present your declaration, nothing at all, then that's a huge red flag regarding proving that requirement that you entered the marriage in good faith. And the other, no, when I talk about red flags, it is things that the officers spot that tend to raise more questions and create skepticism in them about your relationship, your marriage. So, it's not necessary if you say you forgot to include a document, that can be rectified. I mean, the goal is not to miss anything. But if you miss a document that you already have, like your birth certificate, they give you send a request for evidence for your birth certificate, that's different. But I'm talking about where it really raises issues with your application, where now you really it gets you sweating because now they have very difficult questions for you. regarding your application. The goal is to avoid those difficult questions, make it very clear to the immigration officers that you qualify and that everything in your application is credible and true. All right. So that's what I have for you today regarding the red flags in VAWA. Um, so go ahead. If you are thinking about VAWA, you are in the middle of VAWA and you have questions, don't hesitate to contact us because this is what we do for our clients. Go to the link in the profile. You can schedule your own appointment. And just as a reminder, throughout December, we're offering discounts, all sorts of goodies. So go to that Linktree link on the profile page, and it's in the description of the video on YouTube, Facebook, Twitch. Click on it. At the very top, you'll see schedule your own appointment, and eventually you will see when the discount code appears. Go ahead and make your appointment. My schedule is filling up, so you want to do that quickly so I can help you because that's how you're going to get the help. Just reach out and I'll be here to help you. All right, so let me go ahead and I'm going to answer some questions now. So I'm going to scroll through. Let's start with TikTok today, and then I'll work my way around to YouTube and then Instagram. What happens when you apply for your SSN for your fiance and it takes longer than 2 weeks? So it doesn't really mean anything. You have to contact the Social Security office just to make sure that it is in process. Sometimes they're backed up, so just call the office. And I just applied for asylum, and should really I wait 150 days? Can't I apply before that? So no, it's 150 days that you have to wait for. How long does your case take at the NVC? So it could take 1.5 years to 2 years. So I'm not sure if this is a question or comment from you have your parole, you can get married. So if you are entering a bona fide real marriage, then yes. Parole means, so parole is special permission you're granted to come into the country. Sometimes that's granted at the border. Now, the type of parole we're referring to, that we have different kinds of parole. So you have parole that's conditional on your detention. So meaning that you are released from detention pending proceedings. I believe it's parole pending proceedings. That's different. It's also called conditional parole. That is different. You cannot adjust status on conditional parole. You have to make sure you address the court issue first because you're still in court. They're just saying you're released until they're ready to process your immigration proceeding to the removal proceeding. The parole that works for adjustment of status is going to be the one where they grant it based on a significant public benefit or urgent humanitarian need. So in that case, if you're paroled on that basis, then you can qualify to adjust status here. Through a relative or through other means that you qualify for. How long does a T visa process last? So it can range anywhere from 6 months to 18 months. It just depends on how complex your case is. I-130 and I-485 filed concurrently with U.S. spouse since October. And still no biometrics date. Any idea why? They're probably backed up. And that's normal. Sometimes they take a little longer to do the biometrics. Can you apply for VAWA in the middle of an I-130 NOID and pending I-485? Absolutely. So yes, absolutely. We do represent clients in cases like that. Now it is a process, so you want to address it ASAP before you get the denial, because so when you file the VAWA before you get a denial, you can move your adjustment of status application, which comes with your work permit, travel document, over to your VAWA process and keep your process open. And then you can then address your needs as a VAWA applicant. Thanks so much for the love. I appreciate it. After you submit VAWA, how soon can you expect work permit and travel authorization? So the shortest I've seen is 4 months. The longest I've seen is 12 months. On average, you're looking at about 8 to 9 months. What if you've been married for 2 years and husband stole all your evidence and refused to help? Sounds like that might be a VAWA case. Go ahead, give us a call and let's talk to see how best you can approach the situation. How can I apply to emotional abuse? So if you're applying for your status based on emotional abuse, it's going to be through VAWA. Now, the evidence that we use is going to depend on what you have. Do you have text messages? Do you have recordings of your spouse? Do you have pictures of anything that indicates? So, for example, maybe they may not have hit you, but maybe they destroyed your property. Maybe they cracked your phone. So if you have this kind of evidence, that can work, but it depends on no, it's not a one size fits all. It depends on what happened in your case. What kind of emotional abuse did you experience? Remember that the declaration, your statement, is also accepted as evidence. All right, so here I'm now on YouTube. Put those questions in the comments now. So after filing VAWA, my status shows my case is transferred to different office. What's next after that? They'll continue processing it. So right now we are getting transfer notices as well for some of our clients. And that's because they're trying to distribute the work. So they're trying to move things along. So this is why it's being filed being transferred to different offices. Hi there, Sue. My I-130 has been approved. Can I first apply for EAD before filing for I-485? So this is where representation is so important because it helps you to know exactly what to do next and avoid mistakes. Because in this case, the EAD, which when I say EAD, it is your travel document. Your work authorization, work permit, EAD is your work permit. It's dependent on the I-485 being filed. If you don't file the I-485, you're definitely not going to get the EAD. So when we file this, I don't know what your case is, how you qualify for adjustment of status, but when we file this, we file everything concurrently. That means EAD, which is the work permit travel document, along with the adjustment of status. So I put in my petition 2022, but I didn't put in the work permit. Last 6 months, I put it in. I only got a receipt. Did I do something wrong? So it takes a while for the work permit to be processed. So this is where it's very important to understand when is the right time to submit the work permit, because it's so frustrating how long the work permit can take. It can take even up to a year, depending on what kind of application you're filing for. And so you're probably experiencing that right now. It's just that it takes a while. So what if you file taxes and it comes back as single and USCIS asks for it in an RFE? So, I'm not sure what your situation is. If you are filing a marriage-based case, and you're now you're worried about the fact that you filed as single, or the tax person put you as single. Whether this will affect your immigration application, it just depends on what else is going on in your application. In some cases, you're given tax advice as separate and apart from your marriage. You're given tax advice based on the tax consequences. And sometimes the tax person may advise that you file as single rather than married filing separately. Or even though, keep in mind, if you're married, under tax law, if you're married, you're supposed to file married filing separately. You're not supposed to file as single. So that may be an error, and you may have to contact your tax person to point out this error and have them amend your tax return. But if it's something where, say, it's permissible under tax law, but now you're worried about how it's going to look for immigration, then that's going to be a more complicated situation where we have to understand what other evidence have you submitted, and what exactly are they asking for in the request for evidence to be able to properly address that issue. Can I change a pending asylum case to an employment-based green card? So you can't change an asylum to another type of case. It you have to you may be able to file a new employment-based green card, but the problem here is that if usually when you're applying for asylum, you're in this gray area where you may not be able, you're in an a zone where you don't have status because you ended up overstaying the time you are permitted, if that's the case. So you don't have status, and that can affect your ability to apply for employment-based green card. So it's a lot more complicated than just filing an employment-based green card. You have to make sure that you meet all the requirements in regards to your presence here in the United States, whether you continue to maintain your status. So I applied for VAWA, Work Permit and Adjustment of Status, in February of this year. Got prima facie, biometrics, work permit already. Can I apply for advanced parole? Yes. So we always apply for our clients to get their travel document at the front end, along with the adjustment of status application. Work permit and document combo card for U visa, how to get it. So with U visa, you usually have to show that you are the victim of a crime and that you have cooperated with law enforcement in some way. This could be where maybe you witnessed a crime, your name was on the report as cooperating with the police, or you yourself was a victim of a crime and your name is on the police report. Now the part about this that it can be challenging is you do require law enforcement certification to complete the process. And in this case, that requires you to go back to the law enforcement agency that is investigating whatever crime took place, and request that they complete this document. Now, sometimes because law enforcement agencies differ, sometimes it does take some multiple follow-up because it might be a local police station that they are not familiar with the U certification process, and so it takes a little more education uh, to let them know. Sometimes I've had to look up state law to see if the police department is required to consider U certification. So you have to go through that process and then submit an application. And then within about a year and a half to 2 years is when, all being well, it's a properly filed application, you'll get the work permit. Now, the document combo card, so the travel document, it does not come with a travel document. You will have to apply for a travel document separately. And another thing you have to keep in mind is it even advisable to get a travel document? Can a green card holder over 10 years file for you? After marriage, is it safe? What can a green card holder over 10 years file for you after marriage? So it's going to depend here. I don't know if it's advisable in your case. Generally, it is safe, but I don't know in your case whether it is advisable. And that's where the consultation is going to be very important. Can one file for VAWA while married and continue being married? Yes, that's absolutely possible because these things are complicated. But it is something that you have to definitely address in the application. Now, when it comes to the confidentiality piece, we serve as our client's safe address so that this person that's living in the same house is not, they're not going to be, have knowledge about what you're applying for. My I-130 was approved last week. I have for a 5-hour fee for medical. I sent medicals yesterday. I'm married with a USC. Will I get interview waived? See, now you can't hold me to it because I'm not your attorney, and there's no way I can know for sure. But usually that pattern where they approve your I-130, because usually when they do the interview, the main focus of the interview is the I-130. I-130 is saying, is your marriage real? And so if they approve the I-130, then it sounds like you're going towards a waived green card. Someone filed a VAWA petition in 2021. She received prima facie determination that expires in May of this year, but haven't received a work permit. Biometrics was done from October 2021. So that's a long time to wait, and it's definitely outside of processing time. So it's time to contact them and point this out. All right, so I'm gonna go ahead and answer the last few questions here on Instagram and then head out. Tomorrow is gonna be another day where we will, I'll hand out 2 free consultations again by just hopping on, giving you the code, you call the number and the code call, and you'll get your free consult. My husband served me an eviction notice, verbally mistreating me, abusive, gaslighting, controlling behavior. What's your advice? Give me a call. This definitely sounds like a VAWA situation. Definitely. So give me a call. Let's talk. Good day. I'm on an H-2B extension. What steps can I take to look about a green card? So H-2B does not directly lead to a green card. However, if an employer wants to petition for you, then that could be a way for you to get the green card. Good morning. How long after send RFE response you will get a response for the interview? So I've seen a few days to a few weeks, so it just depends on what the situation is. What happens next after my name has been updated for a year now on my VAWA case? Please. So usually they do that sometimes when they do an update on behind the scenes. It doesn't necessarily trigger any immediate actions. Does a U.S. citizen spouse need to travel to the country of their spouse for the interview, or is it on a case by case basis? Okay, so if the spouse is outside of the United States and they're going to the embassy for the interview, they do not need to go to the interview usually unless the embassy requests that they be there. And if the embassy requests that they be there, then they need to be aware because it means that they want to scrutinize the marriage a little closer because usually they don't usually call the citizen or resident spouse to attend the interview at the embassy. I've seen it happen But usually that means they just have a few more questions, more detailed questions about the marriage. I submitted an RFE, medical and affidavit of support over a month ago. How long should I wait for an interview? So it just depends on what availabilities they have. Hello, how much is your service? So the first thing you can do is schedule the consultation. It's usually $150. I am handing out discounts next week. So if you want to wait for that and then book your consultation, then the discounts are only available online for those who want to schedule an appointment. Can my spouse apply for a green card if I didn't pay taxes based on ineligibility? So if you didn't have to pay taxes, then your spouse won't be affected by that. You just have to explain that you were not required to pay taxes. Is it normal to file VAWA but received update? They are now actively reviewing I-130. So if you did not hold your application in abeyance, so your I-485 application in abeyance, meaning tell them to put a hold on the I-130 so they can continue, they can instead process your VAWA, then they will be processing the both of them at the same time. So you would want to make sure you address that. All right, so that's gonna be it for me today. Now, what's your price for VAWA? I don't give quotes here because every case is different, and this is the reason why I do provide individuals the opportunity to schedule a consultation to get legal advice needed that they need, and then also to learn about your case and understand what's going to be required here, and then I provide a detailed quote. But the first thing you can do is make the smaller investment for a consultation to determine whether you qualify, what should you do in your case, how should you move forward, what are your options, and then from there, I talk about whether you qualify and what the cost will be. What if the immigration appointed doctor says the only medical appointment available comes after your interview at the US Embassy? What do I do in that case? So, yes, this is when, as soon as my clients get the letter, that's the first thing I tell them to go do, book the appointment, because they can get backed up too. And what will happen is you will have to go to the interview, but they will tell you that they have to wait for the medical to be completed before they can give you the final decision and give you your immigrant visa. So it means there's going to be a delay. All right. Thanks again, everyone, for your time. I will be back tomorrow. So 12:30 is when you can expect to look out for me. And then I will hand out the 2 free consultations and then talk about another topic I think is of interest to you. Now, one thing I want to state here before I go is the VAWA is one of the pathways to get your work permit and your green card. So while you're waiting for your green card, you can get your 5-year work permit. So they are handing out 5-year work permits for this petition. So the reason I'm doing this is because, as I've stressed before, it's so important for individuals to find the options that work for them. What do they qualify for? In order to get the work permit. But remember, the work permit is not as easy as just printing a paper and sending it in for the work permit. You do have to qualify based on your experiences, based on your family relationships, based on maybe your employment relationship. You have to qualify in some way to get to the work permit. And so that's what I do. Have a good one, everyone. See you tomorrow. Bye-bye. Bye-bye.